So let me just start with some cool karma, which was alluded to just a moment ago. It was 15 years ago tonight and one day that I was honored to receive the Robert Louis Cohn Award, and at that very same dinner, Judge Weinstein was your judicial honoree. So it's a real privilege for me to present the first award in his honor. I don't need to tell any of you this. Jack Weinstein was a towering presence in every respect. A judge of enormous intellect, humanity, and independence. There very well may never be another Jack Weinstein. But you have found someone to receive the first Weinstein Award who strives mightily to meet the Weinstein standard and does so with boundless energy and creativity that seemingly increases with every year. In selecting Fred Block, Jack Weinstein's friend and colleague, you have set the highest standards for this prestigious award. Judge Block is one of a kind. He truly is one of us. He came to the bench from a solo practice that included representing the criminally accused, and with that experience as a practitioner, as a working lawyer for everyday people, Fred Block brought a much-needed human perspective to the bench, very different from the ex-prosecutors and big law veterans who would dominate. He appreciates the challenges of lawyers toiling in the trenches, as well as the human frailties of the clients we represent. Fred Block is a multi-dimensional person. He's a musician, a published songwriter, and the author of several books. He radiates a zest for life and a love of people. He loves the give and take, the exchange of ideas that's inherent in the law, and I'm told that his clerks marvel at his joy in the process. He's renowned for his independence, dedication, and compassion, and some might say unconventionality or quirkiness. I'm sure here in this room tonight are many of you who have experienced Judge Block as he has reflected his interest and concern for the human dimension of judgment. You see it when he grants without hesitation or gratuitous challenge a lawyer's request for special services to help uncover mitigation. You see it in the affability of his manner and his respect for the lawyers who appear before him. And you see it when he crafts a creative way to reduce or eliminate altogether the need for imprisonment. But in the end, all judges are defined by their decisions and how they wield judicial power. For me, two of his cases best exemplify why your choice to confer the first Weinstein Award upon Judge Block is spot on. In May v. Shin, a Ninth Circuit case just decided and soon to be released for publication, he has written a concurrence that will resonate for years. Stephen May is serving a de facto life sentence for a crime for which he may be actually innocent because technicalities foreclose access to relief. Indeed, his sentence of 75 years without parole was interrupted, his sentence was interrupted after 10 years when he was released by a district court granting his habeas corpus petition. But after 4 years of law-abiding freedom, he was thrown back in prison when the circuit reversed over a Block dissent. And there he will likely remain until death. In his new opinion, Judge Block castigates the state of the law as it has evolved over the years to literally take justice out of the equation. He condemns a system that bars the courthouse doors, denying relief when justice cries out for it, and that compels sentences that shock the conscience. That solo practitioner from Suffolk County, who made the Clayton motion, the right of a court to act in the interest of justice for law and order, has now issued a clarion call reminding all of us that the principle of justice should be the hallmark of jurisprudence. Beyond that, the opinion urges clemency for Stephen May and calls upon judges across the nation, to exercise what he calls the moral responsibility of judges to identify injustice and play an active role in promoting clemency. What a testament to Judge Block's compassion and unquenchable thirst for justice. But he has another quality that makes this award so appropriate, and that quality is guts. Society continues to grapple with racial and ethnic disparity and outright racism in the criminal legal system. There is endless debate about how to fix policing, how to prevent police violence, and how to ensure respect for all communities. We defense lawyers have always known that police routinely bully certain communities, falsify facts to justify unlawful searches, conduct deceptive and abusive interrogations, and run suggestive identification procedures. And to our everlasting frustration, courts routinely credit painfully incredible police testimony. We need judges who have the guts to call out police misconduct. All the fixes in the world, training, certification, supervision, are but grains of sand compared to the power of judges to stop abuse. Body-worn cameras were supposed to be an answer. But of course, they're not much help when the cop turns off the body-worn camera at the critical moment. But that's what we're seeing all over the country with increasing frequency, and they always have these cockamamie reasons why they just happen to be turned off at the critical moment. Last year, Judge Block had before him a case in which police claimed an Hispanic woman invited them into her house to conduct a search that led to the arrest of her son. That's right, they claimed that she invited them in. And wouldn't you know it, when the cop who led the way, who did not speak a word of Spanish, went up to this Hispanic lady who didn't speak any English, and when she supposedly invited him in and his team to scour her home, the camera was turned off. Well, in United States v. Rudolfo Garcia, Judge Block found that the entry was unlawful, as was the purported written consent that came after armed police occupied a house for more than 12 hours, and he suppressed the evidence in the case. In his opinion, Judge Block wrote that because the officer was responsible for depriving the court of the best and dispositive evidence, the government failed to meet its burden. But he went further, and he held that the failure to activate a camera required by department guidelines is an adverse credibility factor. To fix the legal system and heal society, we need a lot more judges like Fred Block with an eye on justice and a foot. Among Jack Weinstein's amazing talents was that he was a devotee of haiku poetry. It is my honor to present the inaugural Jack Weinstein Award for Judicial Excellence to Fred Block, reciting a haiku poem penned by Jack Weinstein for his friend and colleague. From out of the West, great man Fred Block came, brilliant judge, great friend, ever young. Judge Block, ever young, on this, your 88th birthday, please accept the New York Criminal Justice.
Norman and I tried a few weeks ago when I was told I was going to give this wonderful award. I said, Norman, I'm not big at awards. You know, these type of pro forma things where this organization has to give an award this year, they're a fair, and 3 people get together in a room, and it's like a beauty contest, and I don't subscribe to that. I said, Brad, do not worry. At your age, this is no beauty contest. And then, my background comes with Jim Soros to visit me, and I had a sense that I was getting this wonderful honor. And so Mike, he couldn't wait until he came into my chambers and said, Judge, I got great news. I got you reversed yesterday in the McGriff case. Well, God bless him. So McGriff, was sentenced to 8 years of lifetime imprisonment for 100 murders. He escaped the death penalty. I became Judge Blockhead because of that. But, the 9th, lifetime sentence was for drugs, and God bless my background. He got me reversed because I could follow fair in the law dealing with that issue. So this person still stays in jail for 8 consecutive murders. So I looked at Mike and I said, Mike, this is what I love about the criminal defense lawyers. Your spirit, your energy to keep the law straight and narrow, even if it's not to make a bit of difference to your client's feeling. And then I told Jim, I said, Jim, I'm more than happy. Don't feel you have to come forward and give me this award. I got reversed yesterday. You have to give it to me. And you didn't get it anyway. So here I am tonight, and it's a special evening, and Norman and I go back a long way. And he deserves a lot of recognition also, because we all know about Norman. So when he was ready to retire, after being with the National Association of Criminal Defense Lawyers as its executive director for many years, he couldn't do it. He's now the CEO of Fair Trials, an international NGO, which is just expanding the rule of law throughout the continent. So, Norman's a special guy, and to be introduced by him is a very special beginning for this evening. Now, I don't have a lot of rules, but I have a couple, and I want to give you one tonight. You have to honor it. I have a few things I want to share with you tonight. I hope it will resonate with you. I think it's relevant. I think obviously it's important to me. But if I go on too long and you get tired of hearing me drone on and on, just say, Judge, stop. This is the only opportunity a criminal defense lawyer has to tell Judge Block to shut up. So I'm counting on you doing that. You have in front of me some notes. This is about Jack B. Weinstein. My hat's off to you in perpetuating his legacy. And there'll be more of me to follow. There's still going to only be one Jack B. Weinstein. And it's just wonderful that you folks have the sensitivity and the awareness to recognize the importance of perpetuating the legacy of that great man. So, I want to talk about Jack a little bit. His wife, Susan, is with us tonight. I'm happy to see her here. And before I talk about me, I'm going to tell some Jack Weinstein stories. I may be the last of his judicial colleagues who spoke to him when he was alive. I called, I wanted Susan, she answered the phone, she turned me over to Jack, and I said, Jack, how are you? He said, thank you, Fred, for calling. I appreciate it. Thank you very much. That was about the end of the conversation. And it passed 3 days later. So, I can't get that last sense of him out of my mind. Ever so humble, ever so grateful, ever so appreciative, so unusual. He, has been on the bench for so many years, but I want to really give you a sense of a few things. You know, he was on the Ground Board of Education brief. I have a copy of the last page in front of me. He's there with Jack Carter, Jack Greenberg, who was the charge of the department. He was a famous professor at Columbia. Jack had recently graduated from Columbia, and he was asked to be part of the writing team. And on the Ground Board of Education brief, there are 4 of counsel. They're the ones that really argue the case, they were the lawyers. But the ones who wrote the brief were the of counsel people. And the first counsel was Judge and the second one was Frederic Marshall. And the last one on the brief is Jack B. Weinstein, Ground Board of Education. When Jack was 70 years old, he contacted Frederic Marshall and he wrote this letter to her. Dear Frederic, I was fascinated by an ABA journal issue recently devoted to you and your honor. The few years I spent under you are a lasting appreciation of relationship and dedication for a new scholarship. Now, as we are all men, I have to decide whether to take senior status, whether you take senior status, is it working out? Okay, whether you take senior status or stay fighting the good fight as a active judge. I'm inclined to go on fighting sincerely and respectfully judge. In June of 1992, he was 70 years of age when he wrote. And Frederic wrote back in July, Dear Jack, I am sorry but your letter from June 2nd got waylaid in my movement. You know that this problem of whether or not to hide or whether to take senior status is absolutely a personal one, and there is no help anybody can get. I have for myself narrowed it down to the doctor, my wife, and me. Together we went over all of the conditions year after year after year, and eventually the doctor persuaded us that it was time to retire, and I retired. I am sorry that nothing I have said is going to help you make, but one thing I would like to add is that it is clear to all concerned that you have more than anyone I know contributed your share to the work of the federal judiciary with all best wishes. Written in July of 1992, and Frederic passed away 6 months later in January of 93. Now, Jack Weinstein stayed on the bench for 28 years after that. He created the concept of an active senior judge. He was talking about the and he created a whole concept where judges of the age they reach can stay on as academics. I've been a senior judge now, I guess, for 18 years. I was told by Carol Emmett today a very good story. So when Frederic passed away at his funeral ceremony at the National Cathedral, Ralph Winter had this to say about him. If I can find it, I'm going to share it with you. Okay, so I can't. But anyway, he praised Frederic, and he talked about his sense of justice, and he went on and on. He railed against injustices whenever he saw it, and the same really applies to Jack Weinstein today. There's so much about Jack, but what also really resonated with me is the fact that he also wrote a haiku when he stepped down as a judge on the bench. And I have that right here. You see how organized I am, right? Yeah, here's what Ricky said to Frederic. The third was the irresistible force for justice, the immovable object against injustice, and a warm, kind human being. That same can be said for Jack Weinstein. So, when he stepped down from the bench a year ago, he wrote a haiku also. I like the way he wrote it out. I like his better. It was calm, it was standing down. Sorry, I must stand down now, leaving you guarding the Constitution. Leaving you guarding the Constitution. So that's the theme of this promise I want to share with you tonight, because you are the guardians of the Constitution. When I wrote about the main case, I wrote 3 opinions on that case. It was astounding that, this really happened. And what was so relevant is that I thought all about you folks, the criminal defense lawyer. It represented to me the epitome of how difficult it is to be a criminal defense lawyer, how challenging it is to be a criminal defense lawyer, how painstaking it is to be a criminal defense lawyer. Because in that case, the jury initially was a hung jury. It was a very thin case, The jury couldn't agree, and they walked out, and the judge declared a mistrial, and they said, down for a new trial. And as that was happening, the bailiff came walking back into the room and said the jury had to give it another shot. The judge turned to the government lawyer and said, okay. Turned to the criminal defense lawyer. And the criminal defense lawyer accepted. The criminal defense lawyer accepted. When I talked to Norman about it, when I talked to Michael about it, when I talked to Jim, they tell me that you get a mistrial, the jury's discharged, you get out of there as fast as you can. But this particular criminal defense lawyer felt he could get in the middle because it's a very, very good case. 1 month later, I stood before the Arizona State Court judge, applying Arizona State law, and had to listen to her sentence his client to effect life in jail. I felt so badly for that lawyer. What a position for a criminal defense lawyer to be in. It's represented to me the degree of difficulty, the challenges of being a criminal defense lawyer. You've got to make those decisions. How are you deciding that in that situation? And look at the consequences this person has to live with for the rest of his life as a criminal defense lawyer. So that is what really impressed me with the main case. I read 3 decisions in it. The last one will be coming out this week. The amazing thing about it is that there was a habeas appeal. The amazing thing about it is that Judge Wade had issued habeas. He was let out of jail. He was going to say after 10 years. And I wrote my first made decision agreeing that he was out of habeas relief. He was out of jail. He was served for 10 years for 4 years. And for some reason, the government, asked for reconsideration, and Judge Friedland agreed. And because of that, he's remained in jail. And here is what she said, which was astounding in her opinion. Let me get it. I've got to read it to you. Give me a second. She said, this. It's going to be here. She reversed herself. She said, while I certainly recognize the seriousness of child molestation, the evidence that May was actually guilty of the 5 counts of molestation Mr. Vickery's on was very thin. May's conviction on those counts was based almost entirely on the testimony of the children who were the alleged victims. Yet, as described in the opinion, that testimony had many holes. The potential that May was wrongly convicted is especially concerning because he was sentenced to 75 years in prison, a term that all ensures he will be incarcerated for the rest of his life. And this evidence belongs to the common image. The significant constraints on the scope of our review, we are not in a position to do more than decide the narrow question whether the proceedings in this case were so egregiously unfair that they violated the Constitution. But I agree with the dissent that this case, and in particular May's sentence, reflects poorly on our legal system. So I looked at that and I said, my God, where have we gone the last 50 years? Where have we gone since the Halcyon days of the Supreme Court where they decided Iran and Gideon and Matt versus Ohio and Baker v. Carr and Brown v. Board of Education? Those are the Halcyon days. And where have we been since Clayton was decided? When I was a young man and I had this opportunity to speak out about how the concept of justice transcends common law, statutory law, constitutional law. It's pervasive. We've lost our sense of justice over the last 50 years. So today, habeas corpus is in death level. Today, we have mass incarceration rates of 2.3 million, more than any country in the world. Today, we have mandatory minimum sentences. 25% of my cases, I'm not the judge, Congress is the judge. 25%. To me, the third branch of government is becoming a twig, and it's getting worse and worse. Today, we have wrongful convictions. Today, we have all sorts of other problems with our criminal justice system. It's a sad testimony that over the last 50 years, we have progressed from the halcyon days of the 60s and the 70s. We've progressed from concepts of justice to where, as Judge Friedman did acknowledge, while she felt constrained by the restrictions of the law to put May in jail for the rest of his life, that she reasonably said that the case in the particular May sentence reflects poorly on the legal system. How sad a testimony that we have arrived at the point in our jurisprudence in our legal lives as criminal defense lawyers where our laws reflect poorly on our concept of justice. So, my first decision was one where I agreed that May should be given habeas relief. My second decision dissented to the fact that Judge Friedman changed the mind. My third decision is coming up this Friday in the Ninth Circuit. You members of the recording meeting about it. I wrote about why I wrote it. I wrote that it was my hope that by calling attention to these injustices, this opinion will be of considerable value to those who will be undoubtedly one day to decide whether the May sentence should be commuted. I believe it is the responsibility of judges who have had the opportunity to identify injustices and the sentencing. Here we go. Play an active role in sharing that information with those who will be passing final judgment on the life of a human being. I believe, therefore, that there is no reason why judges should not play a more regular role in clemency. This is in keeping with the moral responsibility of judges who are uniquely positioned to proceed with justice to others' attention and mercy. So So Ray, is back in jail, and I make a plea for clemency, and I reach out to the bar, and I talk about the fact that he's an ideal candidate for clemency. He has already served a decade of his sentence before being released by Judge Waite, and the record before me reflects that he was a law-abiding citizen during his more than 4 years of freedom before being returned to prison. He never attempted to abscond, even though he knew that if Judge Waite's decision were reversed, he would be spending the rest of his life in jail, and he faithfully complied with his terms of supervised release. So why do I harp on May? To show you how injustice has trumped anything rational and anything reasonable. To reach out to my colleagues to say, you've got to do whatever you can to identify justice whenever you see it, and to reach out to the criminal defense and to challenge you and your organization. What's our responsibility? Do we have a moral responsibility to do anything in the face of injustice when we spite and we know and we see it exists? Do we have a responsibility when we see our judicial system going down the tube? Do we have a responsibility to behave as a dead letter? Do we have a responsibility to speak out or to sit back passively and let injustice prevail? I can't do it. By talking about the guardians of the Constitution. Who are they? When Michael Bachrach appeals a sentence by a judge, regardless of who that judge is, to set the law straight, even though getting a reversal will not make a particle of difference in his client's freedom, he is a guardian of the Constitution. When criminal defense lawyers do not cower when they believe they are right and are willing to challenge the judge, even at the risk of contempt, where's Mitch Dynasty? They are guardians of the Constitution. When criminal defense lawyers represent the most despicable murderer who is a poster child for the death penalty, but nonetheless, doing everything in their power to spare their lives, they are guardians of the Constitution. When criminal defense lawyers risk their health to meet with their incarcerated clients in the COVID-infected horrific conditions at the NBC and Rikers, they are guardians of the Constitution. When criminal defense lawyers challenge the inhumane prison conditions at NBC and Rikers and the abusive treatment of their incarcerated clients, they are guardians of the Constitution. When criminal defense lawyers have to hear and listen to the word guilty over and over and watch their clients being remanded to jail, after doing everything they could do to ensure that they got a fair trial, they are guardians of the Constitution. When criminal defense lawyers take on the cases of the wrongfully accused and those innocent people on death row, they are guardians of the Constitution. When criminal defense lawyers have to take verbal abuse from some judges who don't fully appreciate their degree of difficulty in representing a guilty man, they are guardians of the Constitution. If Judge Weinstein was standing next to me today, I am positive that he would join with me in saluting every criminal defense lawyer in this room tonight as a guardian of the Constitution. Keep it up. We need